All right. Well, thanks for tuning in. I am Candy Martin with Martin Business Solution. And on today, we are going to discuss what is the difference between a will and a trust. Now, this will be a brief summary overview, very basic. I do advise that you consult with your financial advisor, your financial educator, your attorney, your trusted advisor. What I'm going to share today is going to be an overview of what a will is, what a trust is, how it works, and also toward the end, how not just Martin Business Solution, but those of my business partners, how we help all of our clients implement putting a will or trust in place. So if you were invited by someone else, or if you're watching this replay from someone else that is partnered with the Wealth Wave company, please by all means get back with them toward the end and let them walk you through the next step. So let's get right into it. So what is estate planning? I know a lot of times people hear it and they think the rich and famous, and oftentimes the rich and famous haven't even done their estate planning. So trust me when I say estate planning is for everyone, no matter your economic status, social status, educational status. It's all I'm not going to say it's not important when it comes to estate planning, but it is definitely not a determining factor if you are entitled to one. Everyone is entitled to do estate planning. Estate planning is the process of organizing your assets, whatever you own, however little, however much, and wishes to protect your family and your legacy. And sometimes I've run across people say, well, I don't have any family. Even still, you would want to decide ahead of time, before you transition, what you want to happen to the things that you have acquired, accumulated, earned, the things that you value. And you do have a say-so of what you want to happen to it. So three things that we're gonna kind of discuss on today are access distribution. Decide how your access should be distributed after your death, which means you got to do this beforehand because once you're out of here, it's still coming back to get things in order. Guardian designation, name guardians for the care of minor children, and I will also include that if you have a special needs adult that you care for, guardian designation for them also needs to be taken care of. So a lot of times when we hear that guardian designation, oftentimes the special need community gets overlooked in that. So make sure you keep them in mind as well. Your healthcare decision. So these are the things for your healthcare decision or prior to you passing away. So for example, Lord forbid, you're in a car wreck, they rush you down, they heavily sedate you, and they come out and they ask the family, should we chop off his toe or not? And if the family don't know because you did not make the healthcare decisions prior to, or if you haven't designated someone to make decisions on your behalf, it could get a little confusing. So make sure that you take care of those things because it's not just about your estate plan. It's not just about when you transition. It also has some portions of it of why you are living and for whatever reason unable to make certain decisions. All right, so why does it matter? Having an estate plan. Control. You get to decide who receives your access, who cares for your children or special needs adults, and how medical decisions are made. Privacy. You want to keep your access and beneficiaries and final wishes private from the general public, and you want to keep it out of the process of probate. Who wants to sit inside of a courtroom month after month waiting to get word on if your family will be able to take possession of your belongings or your property, or monetary things? Probate avoidance. Avoid probate with our revocable living trust program that I'm going to tell you more about through NetLaw. So I'm going to tell you a little bit about that. It's a quicker process, it's more affordable, and it's more efficient distribution for your loved ones. So it just reduces a lot of stress. You just think about it. If you have minor children and you don't leave it in the hand, you don't put it in your will or your trust, you're leaving it in the hands of a court system that may take months to get to it. while the child remains sometimes in state care versus with a trusted loved family member. All right, protection, protect your family from stress, confusion, and conflict during this difficult time. Without a will or a trust in place, your family may not get a chance to grieve properly, or even sometimes, in some cases, to even put you away. We've seen some famous cases, I'm sure, and then some people may know some people that this has happened to them in their local community where family members could not agree on where to bury someone, and it took months to have someone have a proper burial. You definitely want to avoid all of that drama. So avoiding probate, I can move this up a little bit. Avoiding probate court. Probate is the legal process that takes place after someone passes away, where the court oversees the distribution of their assets and payments of their debt. It can be time consuming, costly, and public, it can be made a very public awareness of what's going on, often causing delays and added stress for loved ones. And it is a process that we have through one of our business partners at NetLaw, where we are able to have a guided platform that makes it simple to create a legally valid trust and ensures that your estate is handled quickly according to your wishes without the delays and costs of probate. Sometimes people say, well, it's so expensive to get a will or a trust. It is so expensive to not have one, and your family have to pay the court and lawyers. We'll talk a little bit about that. Protecting your children. So if you have children and you want to make sure that your children are where you want them to be. Oftentimes, I'll kind of deviate a little bit. I had a client, I won't call the name, that just knew. She was like, hey, my mom will get my children to something happen to me. And so when we were going through the process of just kind of talking it out, and I was explaining to her how it worked, we later found out, just from asking questions and going through the process of getting her will set up. And she was like, well, I'll just do a will. And she still hadn't been convinced on getting a trust. And I said, okay. So when we were going through the process, she learned that the court, even if in her mind, she was like, hey, my mom will get my kids automatically. She learned through going through the process that that wouldn't always be the case because she had three children. She has three children. And the mom technically doesn't have the income to support three children. And she hadn't set up some sort of financial plan that the mom would inherit should something happen to her so that she can financially take care of the kids. So she just asked the question, well, what would happen to them? I want them to go to my mom. What will happen? And they told her, the attorney that we were talking to at the time told her, hey, your children will become a ward of the state until they can either find a foster home for them or a family member that can financially take care of them. And she's like, hey, but what about the person that's going to love them and take care of them? And they had to tell her, look, ma'am, they're going to be looking for numbers. They're going to have some checklist that they got to go by. Yeah, of course, of course they want the best for the children. But according to the law and what the a judge is going to decide is who can financially take care of three children unexpectedly. Not like you're planning to pass away. So the mom wouldn't look good on paper, even though she can have all the love for them. She's going to make sure they eat. And I know that she's going to make sure that they're protected. But without a will or a trust, you leave it up to the court to make the decision. And so she was like, and I just kind of told her afterwards, I said, like if you got a rich uncle that nobody likes and he's a total jerk and you wouldn't leave him with your dog, just imagine if he stepped up and said, hey, I'll take care of the kids because he can financially take care of them. The court probably would side with him because you didn't leave a will. So that is just, that may be an extreme example, but it's a very real example of what happens when you do not leave a will and better a trust in place for your children to assign guardianship. Do not leave it to chance. Lord forbid something happened to your mom, then what? So now here they go through this cycle of being from this place to that place. These are your children, special needs adults, please take care of them. Do it in advance. And then look, keep down the confusion, the family, and have this conversation with them. Don't just assume they want to keep your children. You better ask. All right. So without proper guardian designation, the state will decide who cares for your children. And then with the platform that we use through NetLaw, you can take control and ensure your children are raised by the people you trust the most. And if it's not family, I mean, there's a whole lot of things you just got to go in that we don't think of sometimes. So medical decision. Like, let me get a little coffee on this one. All right, so medical decision, estate planning, as I mentioned earlier, is not just about when you transition, but it's more about, also including your wishes about your medical preferences and making sure that they are honored and that your loved ones aren't left in the dark to decide. Can you imagine the weight of having to decide if you would approve of something or not? And if you got siblings and they're in there like, hey, um, mom said, do not resuscitate. Someone else will do everything you can to save her. The medical team is sitting there like, hey, do we resuscitate or do we, or do we unplug her? And if you don't have this in place, the siblings are now fighting, and then they'll pull straws or something. The medical director got to come down and make a decision. Someone who doesn't even know your loved one or don't know you to make a decision for you. So leave your instructions and leave them clear. Eliminate uncertainty. Clearly state your wishes so your family isn't left guessing in a medical crisis. Because let me tell you, when you have a crisis, people aren't really thinking, they're stressed, they're, overly concerned. Appoint decision makers, legally assigned trusted individuals to make medical decisions if you are unable to. Define end-of-life care. Outline your preferences for life support and treatment in serious or terminal conditions such as blood transfusions, amputation, of course, the life support, obviously, and things of that nature. There are some people who in themselves, they may decide, you know what? No amputation. I don't care what it is, and your family members in the hallway trying to decide, do I save their life? Do we chop the toe off or not? I mean, and so they're toying back and forth and they make a decision that you are not happy with. And now the family is forever in turmoil. You're looking at the cost of putting this in place. Look at the cost if you don't. Share health information. Authorize access to your medical record through a HIPAA release so care decisions aren't delayed. I really stress this if you have a young adult that's going to be going off to college or to the military, make sure that you do put this in place, this HIPAA authorization, because if you have a child, well, I say child, but a young adult away at college, something happens, you rush over to the hospital, 2 states over, and they ask, do you have a HIPAA on file? If you do not, they will not be able to disclose information with you. I know they're 18, 19 years old and they're still your baby, but according to the law, without a HIPAA release, they cannot share information with you. Net law probate avoidance package. So let's talk about some of the things that we help clients put in place to avoid the drama of uncertainty. Last will and testament, revocable living trust, personal property memorandum, assignment of personal property, financial power of attorney. And that financial power of attorney, just think about it. If you are in a coma or in some sort of long-term facility where they're not letting you make decisions. Okay, who's going to pay your house note while you're out? In this economy, people can't pay 2 house notes, so they need your funds to pay your bill. And in order to access them, the bank is going to require that they have some financial power of attorney. So you want to make sure that you have all your things in place. Medical healthcare, surrogate designation, your HIPAA authorization that we just spoke about, and your living will and advance directive. So some of the added things that go into the will and trust, there's a cloud storage space. I'm in Louisiana, and hello to everybody all across the US, but I'm in Louisiana, and I feel like we're the hurricane capital of the world. I don't know if we're not, I don't know where we are on the list, but good gracious, we have had our share of hurricanes. and paperwork gets damaged, get lost, get misplaced. And so with this service that we offer, we also include a secure cloud storage, where you can take your will, your trust, and other documents, passwords, paperwork, important instructions, and you can scan them in and put them in cloud storage, along with the paper storage. Because I have both. I'm just old school. I just believe in having paper, but the cloud storage is an added peace of mind. It has a guided Q&A format, so the process is very simplified. And we also have ongoing support, customer support for questions and assistance. So it's not like you're one and done. If you have questions, we're here. We partnered up with NetLaw to make sure that you get all your questions answered through the process and even after. With our services, your spouse can plan theirs at no additional cost. Theirs is included as well. So it's in a sense, for lack of a better way to put it, it's like a buy one, get one free for your spouse. Legally valid in all 50 states. It is a self-guided platform, no legal experience needed because the attorney group has put it together. Free lifetime edit to your document. So let's say in 2 years, and let's say you're single now and you got your will and your trust. 2, 3 years from now, you get married. You may need to go in and make some changes. Or unfortunately, on the other side, if you are married and 2, 3 years from now, you go through a divorce, you definitely want to make sure that you edit your will and your trust. There have been countless people that have passed away, that have remarried, they have new families, and life went on after divorce, but they forgot to change their beneficiaries and they forgot to go back and amend their wills and trusts. And now the ex-wife or the ex-husband is making decisions that your current wife or your current husband cannot at the time of your transition. So you definitely want to avoid that drama for your family. So there is lifetime edits to your document. And just for you fur lovers, we do have a pet trust too as well. I know, who knew that even existed? But if you don't, put that in place, someone has to make a decision about your pet as well. I mean, I don't even know how many people don't think about that. Who's going to take care of Rover in your absence? So if you care about the pet, you might want to make some arrangement for him as well. All right. So how much does all this cost? We hear about wills and trusts and we start thinking the lavish lifestyle of the rich and famous. And how can we afford to do this? And so it is very affordable. So the essential package, and remember we spoke about, remember, if you're married, your spouse is included as well. So you have the last will and testament, your financial power of attorney, your healthcare surrogate, advanced directive living will, your HIPAA authorization, documentation, execution instructions, letting you know, hey, once we go through all of the proper paperwork, these are your next steps to make sure that everything is checked off, all I's dotted, all T's crossed. Probate avoidance, which is where your trust comes into place. It includes everything that I just mentioned, and it also includes the revocable living trust for the children and the pet, if you have one, or if you don't have one now, you need to later come back and add it, fine. Personal property, your property memorandum, and the funding instructions on how to put your items inside of a trust. I know a lot of times when I hear the word funding, people automatically think more cost. No, funding means how to put your things that you want to protect inside of the trust. I don't know why they picked that word, but hey, it's attorney talk. So it just basically means how to put your items from where they are to where you want them to be. All right. And as I had mentioned earlier, if there is a special needs child or special need adult, this is an addition to. So you have to have one of the two, the essentials of the probate avoidance, and then you add on the special needs trust because that's a separate set of instructions and paperwork in that regard. So you have to have two sets of things. All right, so what I'm going to do at this time, I am going to allow for any questions, comments, concerns, and let's see. All right, so if you have a question, ask away or comment, but I definitely want you to make sure that you contact the agent that shared this video with you, or if you're watching the replay, and you can go to our website, martinbusinesssolution.com, and there you can schedule a complimentary consultation where we can go through this process step by step and get you and your family protected. So at the time, do we have any questions? All right. Well, that is going to conclude our workshop for today. And once again, thank you all for taking the time to come on.
Thank
Thank you.